My lords, my ladies, before I get going, I should say that when I introduced the representation at the start today, I said that Mr Nicholson was accompanied by Ms Catherine Pickard, because that was his junior for the skeleton. That is, however, not the position as regards representation today. Mr Nicholson has the assistance of Ms Maruna Berkariu, and my apologies for getting that wrong. I was on serious issue to be tried against Interdigital, and I've dealt with the judge's reasons relating to the alleged unfairness of declaratory relief against Interdigital. And as the court knows, essentially we say that if the claim against Avanci is proceeding, then fairness concerns fall away. That's the first point. The second point is that even if the claim against Avanci is not proceeding, Avanci will assist in practice, and therefore the fairness concerns fall away. The third point is that the judge was wrong to be examining arguability in isolation without regard to the participation of Avanci. And the fourth was that there is no unfairness to the other parties, in this case proceeding without their participation, given that Avanci is well able to defend their interests, and there is no reason to believe that any of the other members have anything more to add than Interdigital says it has to add, which is not a great deal in terms of justifying the offer as FRAN. They know, they say, insufficient to justify it as FRAN. The offer is Avanci's creation. And indeed, when one looks, this was the point I was on when we broke, when one looks at infringement claims, where members of the pool bring infringement claims, there is no suggestion that when they say, well, we've made a FRAN offer through the pool, that they then join the other 67 members for the purposes of making that submission. There's no more requirement to do that than there was for Nexus to sue all of its employees in the Supreme Court case I showed you earlier. Now that deals with the judge's reasons in relation to alleged unfairness. There is then a series of respondents' notice points which Mr Raphael relies on, additional reasons why it's said to be unfair or unjust, relating to third-party disclosure and the such like. We've addressed those in our supplementary skeleton at paragraphs 3 to 6, and I'll hear what Mr Raphael has to say on that. Interdigital also takes further respondents' notice points, which we addressed then in paragraphs 7 to 10 of our supplemental skeleton, all of which turn in the end on the inability of anybody other than Avanci to grant the license. Interdigital's central point in that section of its respondent's notice is to say, well, we cannot grant the Avanci license, and therefore it could never serve a useful purpose to determine whether it's FRAND or not. And we say that that simply doesn't follow. The assumption here seems to be that we are asking for specific performance against Interdigital. We are not. And that's not indeed, as I pointed out, how FRAN cases in this jurisdiction have proceeded, at least in relation to the ETSI obligation. The proceedings seek to test whether an offer made on Interdigital's behalf under its patents is or is not FRAND. And having chosen to offer its patents via a joint licensing arrangement, and in circumstances where it is accepted as arguable for jurisdiction purposes that in licensing on behalf of the members, Avanci is discharging or purporting to discharge their legal obligations, there can be no objection to testing whether, by making that offer, Avanci is making a FRAND offer on Interdigital's behalf or not. And the fact that the only machinery to put that right will lie through the machinery of the Avanci pool, rather than unilaterally with Interdigital, does not rob the declarations of their useful purpose for all the reasons I have already explained. Indeed, one can test the point this way: if a claim had to be against a single person or group of companies which both owns all of the patents and could grant the platform license, which is the premise on which this argument proceeds, then that person does not exist. Because the distinguishing features of this scheme are that ownership of the SEPs is separated from the party which is authorised and appointed to licence them, and these SEPs of multiple owners are then licensed together. And if correct, this point about inability to grant would in effect render the Avanci licence immune from any legal scrutiny simply because of those features of the scheme. And we say the judge was clearly right not to adopt any such line of reasoning. Indeed, arguably it exposes one of the oddities of this case, because we have the agent saying it shouldn't answer the claim because it's not the principal, and we have the principal saying it shouldn't answer the claim because it cannot defend the offer made on its behalf by its agent. My lords, my lady, it's worth remembering at this point that the question, as I've already emphasised, is simply whether the declarations are summary judgment material, in the sense that they are bound to fail. And that is not a conclusion which should have been reached about the Fran declarations against Interdigital. They are a properly pleaded claim. And let me deal finally in this context with a point that's made by my learned friend in his skeleton at paragraph 31, that there might be no useful purpose against D2, even if there is a useful purpose against D3, because it is D3 which made the Fran declaration and not D2. Now that is, for all the reasons I've already explained, entirely flawed. First of all, D2 is the owner of the patents in suit. And secondly, D2 is bound by, as I explained earlier, the ETSI obligation as an affiliate of D3. So that was my third of 7 topics. That then brings me to the fourth of 7, which is representative status of Interdigital. As the court will have seen, D3 is sued in the particular claim as a representative of the other members. Alternatively, of the other members except for the one with whom Tesla already has a bilateral license. My own friend grumbled a little bit there. Perhaps I can show you. Paragraph 26 of the particular claim, core bundle, tab 15. Claim is brought against the third defendant as a representative of all Avanci 5G full members, brackets, alternatively, all such members which do not already have a bilateral license with the first claim.
Just go to the skeleton from Mr Justice Fancourt. It's on tab 28.
My own friend has a point he wants to make to you, and I'm sure I'll have plenty of time to make it. Now, the judge directed in paragraph 124 of his judgment that the proceedings may not be pursued against D3 on that representative basis. Now, I do not need to succeed on that issue for the appeal overall to succeed. The claim against Avanci and Interdigital is, for all of the reasons I have already explained to you, perfectly well constituted, even without the representative aspect. But we do say that the judge also erred in concluding that the representative aspect should not proceed. The leading case is, of course, Lloyd and Google, which is in Authorities 2 at tab 25. This was a case in which an individual, Mr. Richard Lloyd, sought to bring proceedings against Google on behalf of approximately 4 million people for alleged breaches of the Data Protection Act 1998. And the Supreme Court decided that compensation under the Data Protection Act depended on the extent of unlawful processing in any given case, meaning that on the basis of a position already accepted by Mr. Lloyd, it couldn't proceed as a representative claim. And one can see that it turned on that issue from paragraph 5 in the Supreme Court, which is at bundle page 717, report page 1227, and in the 7th line we can see Mr. Lloyd accepts that he could not use this procedure to claim compensation on behalf of other iPhone users if the compensation recoverable by each user would have to be individually assessed. So it turned in the end on that question of law, the effect of which was common ground. But the Supreme Court did explain at considerable length and in detail the history and origins of the representative claim procedure. I can pick it up at paragraph 33 on bundle page 723. We can see 19.6 is set out, where more than one person has the same interest in a claim. A, the claim may be begun, or B, the court may order that the claim be continued by or against one or more of the persons who have the same interest as representatives of any other persons who have that interest. The history is set out from paragraph 34 onwards. And a long time ago, there had been a rule about complete joinder, that you had to join everybody materially interested in the subject matter of a suit. And essentially, the following paragraphs explain how the representative rule was part of a process of moving away from the absolutism of that rule. And we can see that in paragraph 37, for instance, in the citations from the Maltby case, next to D, the general rule which requires the plaintiff to bring before the court all the parties interested in the subject in question admits of exceptions. The liberality of this court has long held that there is of necessity an exception to the general rule when a failure of justice would ensue from its enforcement. And there's further citation to the same effect. I can't and won't go through all of this, but paragraph 41 explains how in Duke of Bedford and Ellis, the House of Lords disapproved a previously restrictive view to the representative rule. And we can see in the citation from Lord Macnaghten, in all other respects, I think the rule as to representative suits remains very much as it was 100 years ago. That it's a simple rule resting upon convenience. That Lord Eldon had taken as broad and liberal a view on this subject as anybody could desire. And then there is citation from Mr Justice McGarry at C on the following page, from John and Rees. This explanation made it plain that the representative rule is to be treated as being not a rigid matter of principle, but a flexible tool of convenience in the administration of justice. And then Taff Vale, the principle on which the rule is based forbids its restriction to cases for which an exact precedent can be found in the reports. The principle is as applicable to new cases as to old, and ought to be applied to the exigencies of modern life as occasion requires. So one doesn't need an exact precedent, you can apply it to the exigencies of modern life. At paragraph 45, we see further confirmation that there is no need for a cause of action in an action for a declaration. The readiness of English courts to give judgments declaring legal rights where it serve a useful purpose has much increased since 1910. An important step was the decision of the Court of Appeal in Hannay, which held that a declaration can be granted at the instance of a claimant, even if the claimant has no cause of action against the defendant. There are then a whole series of subsequent paragraphs emphasising the same points about the need for flexibility and it being a flexible tool of justice, which run all the way through from, well, I emphasise 48, 59 and 68, but the bit I very much need to show you then is on same interest at page 735. Well, we can pick it up actually at paragraph 68 on 734 at the bottom, next to H. I also agree with the view expressed in Carney that the very simplicity of the representative rule is in some respects a strength, allowing it to be treated as a flexible tool of convenience in the administration of justice, and applied to the exigencies of modern life as occasion requires. And then in paragraphs, the sidelined passages from 71 onwards consider the same interest requirement. Paragraph 72 in particular makes the point that there is a distinction between cases where there are conflicting interests between class members and cases where there are merely divergent interests, in that an issue arises or may well arise in relation to the claims of or against some class members but not others. And it's said that divergence is insufficient. We have further reference to purposive and pragmatic interpretation of the requirement at paragraph 73. And then we see from 75 that the court in any event has discretion. And at 77 that there's no requirement of consent, as the ability to act as a representative under the rule does not depend on the consent of the parties represented, but only on community of interest between them. So there's no need for them to take any positive step or even to be aware of the existence of the action in order to be bound. The rule does not confer a right to opt out of the proceedings. And then skipping the brackets, it is, however, always open to the judge managing the case to impose a requirement to notify members of the class of the proceedings and establish a simple procedure for opting out of representation if this is considered desirable. Now, we submit, as the court knows, that in this case, all the members of the pool have the same interest, namely establishing that the terms on which they are offering their patents for license through Avanci are indeed frank. There is no evidence of any licensee taking the view that the terms offered through Avanci are not frank. And it is perfectly sensible and pragmatic, we say, that the interests of the members are represented by one of them, rather than having 67 different defendants with 67 different law firms and counsel and exposure to costs. And that is particularly so when we know that if the claim proceeds against Interdigital, whether as a representative or otherwise, Avanci not only wishes to participate but also to be a party. And it is important to, in this regard, to understand the basis on which the judge resolved this issue. If we go to the judgment, please, in Core Bundle Tab 10, and if we go, please, to paragraph 111, which is page 137 of the hard copy, and therefore I think 139 of the electronic, we can see the judge said that at first blush, it appears that Interdigital and the patentees have the same interest in the claim, and explains all of the reasons why. We then see that Interdigital made submissions to the contrary, paragraph 112. And paragraph 113, the judge said the evidence of actual conflicts of interest was rather thin, but perhaps unsurprisingly so given the confidentiality. I am not convinced on this evidence that there exists an actual conflict of interest in relation to the defence of Tesla's claim. Interdigital did not identify a single patentee with which it had a conflict of interest relating to the defence. However, it is easy to see that there could easily be a conflict of interest between Interdigital and one or more of the patentees. I cannot determine now that there is or will be no conflict of interests. Accordingly, if the representative proceedings were allowed to continue, it would need to be on the basis that each of the patentees was notified of the proceedings, provided with the claim form and pleadings, and given a right to apply to opt out of being represented by Interdigital on sufficient cause being shown. And he makes clear that that opt out would be to become a self-represented defendant. So the judge took the view that there were no actual conflicts of interest, there was only a risk, and that risk could be managed by having an opt-out representative process. However, the dispositive concern then arose at paragraph 115 onwards, and that was the point that most of the patentees are outside of the jurisdiction of the court. That's, I think by that the judge meant they're not domiciled in the UK. And B, it is not proven that each of them has UK or UK designated 5G SEPs. Were any overseas patentee to be joined as a defendant to this claim, there would therefore be a requirement to obtain permission to serve them out of the jurisdiction without the ability to rely on Gateway 3, based on there being an existing claim against IDH that the court should try. It might not be possible to establish a gateway against a patentee without UK patents in its portfolio. Now, of course, if I am correct that the claim against IDH is perfectly good, and as I will come to, was served validly in the UK, then that concern does not arise. But the judge then goes on, and indeed I think the same also applies if the claim against Avanci is a good one. The judge then goes on to explain a concern from paragraphs 116 to 119, that it would enable parties to be brought before the court over whom the court would not otherwise have jurisdiction. And the judge's concern in 118 was that it was likely to be jurisdictional overreach in most cases for representative proceedings to be used to bind a person who could not have been sued in the courts of this country. Now, that was a point which was ultimately, it seems, dispositive on the question of the representative claim, because that was the reason that the judge in the end decided that what he would otherwise have been inclined to, i.e. opt out, didn't work. Now, that wasn't a point we had anticipated. Ultimately, it transpired to be very important. It was a point that the judge raised with the parties, not during the hearing, but while he was writing his judgment, and he sent the parties an email, which you have in core bundle at tab 27, which essentially raised the point, said he wasn't asking for any further evidence, but was it the case that no one had put in evidence on how many of the members had UK patents? Now, since we hadn't anticipated that point, and since it apparently played an important role in the judge's decision, we applied, when filing this appeal, for permission to rely on further evidence in Hopewell 5, which is at tab 26 of the core bundle. As to the test, although Ladd and Marshall, it remains valuable guidance, that does not constrain this court's discretion to admit additional evidence, and we can see this from Authorities tab 2, Authorities 2 tab 27, and at page 827 of the bundle, the hard copy bundle. In Mex against Ford, a recent decision of this court from August, the court refers and repeats the guidance in Al-Sadek at paragraph 26. This court has a discretion to receive evidence on appeal which was not before the lower court. The well-known test in Ladd and Marshall continues to provide important guidance as to the exercise of the discretion, although the discretion is not confined by it. Evidence may be admitted where the test is not fulfilled or not admitted where it is, if either is dictated by furtherance of the overriding objective. And then in 142 there is reference to the Ladd and Marshall test. Now, we do say Ladd and Marshall is met here. Point 1, the evidence could not have been obtained with reasonable diligence for use at first instance, because this is a point that the judge raised while writing his judgment. Secondly, the evidence probably has an important influence, because it seems that this was the point which most troubled the judge, or the only reason indeed why he didn't allow it to proceed as an opt-out representative claim. And thirdly, the evidence is such as is presumed to be believed. And the evidence is an analysis by my instructing solicitors, Powell Gilbert, as to how many of the members of the pool have at least one UK SEP. And Interdigital, whilst opposing the application, has submitted responsive evidence, which is in Brody 6, which is in tab 29. And we've set out the net effect of it in our supplementary skeleton at paragraph 15. The net effect is that there are either 57 or 53 members of the pool, depending on how one counts it, who have at least one UK SEP. And Ms Brody explains that the difference arises because there are 4 members, Equo, New Radio, Ofino and Sol IP, who may, according to the Ipsum database at least, have assigned their UK patents to others. That's how the difference between 53 and 57 arises.
But I understand from that if Hopewell 5 comes in, you don't resist Brody 6 coming in.
Indeed.
Can I ask you, in order to say that you could not have obtained the evidence of reasonable diligence, you have to gloss that, don't you, by saying that could not have been obtained with reasonable diligence on the basis of what you understood were the important issues in the case.
I think that's probably fair, yes.
And do you have any support for that? And I'd always understood that the first limb simply meant could you have obtained it for the trial, the first hearing, not whether could you have understood that it might assist your case.
Well, I think certainly construing that, I don't want to get into rewriting Ladd and Marshall, because in the end there is a broader discretion than Ladd and Marshall anyway. But the submission would be that construing the first limb of Ladd and Marshall consistently with the overriding objective, in circumstances where a point has arisen only in the course of writing the draft judgment, which ultimately transpires to be dispositive, and which the judge has said he does not want any additional evidence on, then a party couldn't, with reasonable diligence, have anticipated that it was expected to put in evidence on that point.
Yes,
that would be the...
But that's not what the first limb is it, of Marshall?
Well, I think it always rests on an appreciation of what the issues are or are not in a case.
Oh.
But my lord, if my lord is right, and I approach the question on that basis, and therefore we're not within the first limb of Ladd and Marshall, there is in any event an overriding discretion under the overriding objective. And in my submission, in circumstances in which this point has only arisen at the draft judgment writing stage, and where it has apparently played a very significant role in this issue, it is indeed in accordance with the overriding objective to permit that evidence to be put in. And my lords, my lady, if the court considers that the only parties who it is proper for Interdigital to represent are those who do have UK SEPs, then we are content to proceed on the basis that the representative claim proceeds with Interdigital representing those 57 or 53 members. That is not a rolling redefinition of a class, but rather a simple response to a concern raised by the judge for the first time in the judgment. If the other members, either 10 or 14 of them, don't have any UK patents, then they are in a materially different situation anyway, because they could not have been suing Tesla in the UK. But in any event, we do say that the remaining 10 or 14 are very arguably necessary or proper parties, and so could have been served through Gateway 3 anyway. Now, the judge's concern was that if the claim was only viable with the additional 10 or 14 members, then those members would be presented with an unfair choice between submitting to the jurisdiction or being represented, as they put it, inadequately. So as they, by they I mean the judge, said. Now, we say, for all the reasons I've already explained, this claim is perfectly viable in any event, and therefore that concern doesn't arise. But if that were not the case, then that would demonstrate why these 10 or 14 were necessary or proper parties in the first place. And if they could have been served under Gateway 3, then there can't be any unfairness in them being bound by representative proceedings, even on Interdigital's own case. We do also submit that the argument that there is a hard-edged requirement to show, this is a respondent's notice point that Interdigital take, that there is a hard-edged requirement to show that every person represented could have been served through a gateway. That would be inconsistent with the broad and flexible approach identified in Lloyd and Google. That's the point we make in paragraph 15 of our supplemental skeleton. The judge did not adopt that line. The only authority identified by Interdigital on this issue is one of the first instance decisions in the Prudential against Newman litigation, which you'll no doubt be shown. But that decision is not about the jurisdiction of the court at all, and is instead about not making a representative order where it might bar a substantive defence, as you will see. So no authority has been identified for this alleged hard-edged approach. And of course, representative claims, as we saw, can sometimes be concerned with thousands, tens of thousands, or even millions of people.
That may be so, but that's because the representative can stand for those tens of thousands without needing to trouble the tens of thousands or millions, because you assume that they are in exactly the same position. And what Lloyd and Google tells us, if you do actually have to look at the individual positions of the tens of thousands, then you can't do it, because the representative can't just represent them. Now what we have here, you say they all have the same interest, that is the setting of FRAND, but it involves or may involve looking at the individual positions of each of the patentees, doesn't it?
Well, at this stage, there is no basis for supposing that it will. And let me explain why. And that's why one of my points on the facts earlier was this, that the only evidence is that the rate was devised by Avanci after discussions. There is no evidence that the rate was devised using their comparable licenses. There is no evidence that the rate was devised...
What does that matter? If the court, if you're saying that's not FRAND, and the court's got to set FRAND, what Avanci did doesn't actually matter, does it? Or doesn't necessarily matter?
Well, it will matter strongly, because that will be Avanci's justification on behalf of the people who it represents.
Well, it may be part of its justification, but once it's before the English court, there will have to be disclosure and consideration of all the factors that would usually go into a FRAND determination, and that's quite a complex process, isn't it?
And the way the judge dealt with this issue was by saying, look, as I showed my lord earlier, to say, I don't have any evidence at the moment there is an actual conflict of interests on this issue. I have, I think he said, rather weak or whatever it may be. I can see that that might happen at some point in the future, but the way to deal with that is to have representation on an opt-out basis. That was the judge's way of dealing with
not least because the other 70-odd licensors may not want the representative to see all their sensitive documentation, presumably, to defend the FRAND.
Well, that is if we get there, because at the moment, this court is in no position, the judge was put in no position to suppose that Avanci's justification for the rate that it has advanced, or indeed any other rate that it might choose to advance, will depend on the confidential information of its members. Indeed, there is no evidence, as I emphasised earlier, that confidential information was ever known to Avanci when it was setting the $32.
That's only one side of the coin. I mean, one doesn't go to a trial only on the basis of one party's position. You go to go to trial on the basis of the competing arguments, and that's going to require disclosure of the documents which will be necessary for the court to determine Frand.
It may do.
And that's going...
Trouble is, one doesn't know.
Yeah.
Suppose the claim is defended on the basis of entirely a top-down approach. You would say you don't need any of that. But of course, at this stage, we don't know.
Yes, I think the point is we don't know, and that the judge did recognise that there was the potential for this situation to arise, but that the right way to deal with it was to allow an opt-out approach. And it's worth bearing in mind that this claim now has been on foot for a year. There can be no question that Avanti must have informed its members as the agent of those members of the existence of these proceedings. My learned friend shrugs his shoulders, but Avanti is the agent of 67 SEP owners. It is utterly unrealistic to suppose that as their agent it would have been sued in the English courts on the question of whether the offer is Frand and will not have told them about it. Here we've not received a single letter from a member saying, I would want to be represented. The evidence does not identify, as the judge recorded, any member who would have any specific interest in all of this. And of course, the reason that that's the case, we know from Interdigital's own evidence, is because the offer was presented to the members on what Interdigital itself describes as a take it or leave it basis. But we are told, if insofar as there is anybody who knows how to justify this rate, it must be Avanti. And they will be there.
Yes, but you're going to... Forgive me, I keep going back to that. But you're not going to accept what they say. And you're going to require it to be determined by the English court.
And, my lord, yes, that's right. And, my lord, if the contentions that we advance in response to a case in defence of the rate, which I do not yet know, create a conflict of interest between one or more of the persons currently represented on our case by Interdigital, then at that point they would have the entitlement under the judge's approach to opt out of the representation and to become a self-represented defendant. If and insofar as the points that could be made by Avanti on their behalf were regarded as being insufficient.
Can I ask a slightly different question, which is why Interdigital?
There is evidence on this which we cite in our supplemental skeleton. As the evidence explains, Interdigital, according to one of the studies in the bundle, is one of the top 10 patent holders in the pool. It is, as we make the point in the evidence, one of the an extremely regular litigant in these courts on the question of Frand. It brought a case against Lenovo. It brought a case against Oppo. So it has regularly chosen these courts to settle the question of Frand. And of course, these courts have only just very recently determined a Frand rate under Interdigital's smart portfolio in relation to smartphones, which we're told, at least by the email that we got from Avanti, is the basis on which, that I showed the court earlier, is the basis upon which they seek to justify the offer as Frand. Comparison with uses in smartphones. And what's said against that? Interdigital says, well, you're trying to target one of the big boys, people who've got more of an interest than we have. But we don't accept that they are not. They are. I
think the point is actually the opposite. They're saying you should have targeted a larger holder and didn't.
Well, perhaps, but they say, well, maybe we should have gone for numbers, instead of going for number 10 on the list, we should have gone for number 7 or whatever. Another of their points is, well, you should have sued British Telecom or Vodafone instead, because they are domiciled in the UK, and that would have made things easier for yourselves. But
sorry, I don't understand that. They don't produce vehicles.
Well, BT and Vodafone are members of the Avanti pool.
Right, yes.
So one of Interdigital's points is, well, why not sue BT and Vodafone? Because they are domiciled in the UK. As it happens, based on the evidence that...
Sorry, this is in their capacity as SEP holder, right? Okay.
Yes, exactly. Yes.
Okay, and
But
what's your answer to that point?
The answer to that point, in relation to British Telecom, the answer is that the further evidence has demonstrated it seems that they don't actually own any relevant UK SCP. And in relation to Vodafone, they do not feature in that top 10 table that we cite in the supplemental skeleton at all. So they would certainly be subject to the "you're suing one of the little guys" concern. But I do come back in the end to the point that I made earlier based on TNS and Nielsen. In the end, one doesn't have to identify any particular commercial reason for bringing a revocation claim. There's a public interest in bringing them. But the reasons for suing Interdigital are set out in the evidence, and I hope I've summarised.
All right.
Before leaving representativeness, there's a further flaw in the judge's reasoning that I need to re-emphasise, and that is that at paragraphs 120 and 121 of the judgment, the judge approached representativeness on the basis that Avanci would not be a defendant, and therefore the relevant information and documentation would not be available. And for all of the reasons I've already explained, we say that was the wrong approach. So that's what I want to say on representativeness. That then brings me to the fifth of my 7 topics, which is CPR 63.14 and the gateways. And logically, the starting point here is CPR 63.14. The judge deals with this at paragraph 103 of the judgment. When dealing with, this is the end of representative capacity, in fact. Having concluded there's no real prospect of the court being able and willing to make FRAND declarations against IDPH alone, that's D2. He then says, that means that IDH and Avanci cannot be joined as necessary and proper parties by this means. And then deals with 63.14. I would have held that the claim to a FRAND license of the patents in suit, in the alternative to the patent claim, was a claim relating to those registered rights within the meaning of CPR 63.14(2), but it takes Tesla no further because a licensing claim against IDPH alone would be struck out on the basis that it cannot effectually be tried and that declarations relating to the interests of 65 plus non-parties would not be made. So now I've dealt with the objection to proceeding against Interdigital alone. We say there's no unfairness to Interdigital in determining whether an offer made on its behalf is FRAND or not, and I won't go back over that. If that is right, then the judge held that that FRAND declarations claim against D2 had been properly served on D2 within the jurisdiction under CPR 63.14. And that has obvious consequences which the judge didn't consider when we come to look at appropriate forum, because it means that as regards D2, this was a service in case. And if the judge was right in this conclusion, as we say he was, then the position in implementer commenced claims will be symmetrical with that in SEP owner commenced claims. In SEP owner commenced claims, a claim for infringement is made and a claim for FRAND declarations on the back of it. In implementer commenced claims, a claim for revocation and for declarations of inessentiality is made with claims for FRAND declarations on the back of it. And we say the judge was right in that conclusion in paragraph 103. This court considered CPR 63.14 in the Activist and Eli Lilly case, which is in Authorities 1 at tab 2. This was the jurisdiction decision in the activist litigation about pemetrexid. And this was a case in which declarations were sought as to whether a given product infringed French, German, Italian and Spanish patents. Now, if we go, please, in the hard copy bundle to page 53, at paragraph 77 in the judgment of Lord Justice Kitchen, as he then was, there's consideration of 63.14. Now, I should point out that this reasoning is strictly obiter, because the court had already concluded that the claims had been validly asserted pursuant to an agreement to accept service. But the court did consider it, and at paragraph 77, we can see that the contention was that under 63.14 you could validly effect service not just in respect of the UK designation, but all the other designations the subject of the proceedings too. And we can see what 63.14 says. Subparagraph 2, a claim form relating to a registered right may be served and then at a particular address given for that purpose within the jurisdiction. And at 80, we can see activists describe their argument as simple. It is that foreign designations of the patent are inescapably related to the registered right because they're all designations of the same patent and have identical wording. And at 81, Lord Justice Kitchen says the argument is indeed simple, but in my view is also clearly wrong, and the judge was right to reject it. He says that 63.14 is intended to provide a means for service of claims concerning patents under the 1977 Act, and respect of which an address for service has been given in the UK Patent Office Register, provided it's in the UK. 63.14 is specific in its terms and correspondingly limited in its scope, and then the critical point in that case was foreign designations of a UK patent are not patents under the 1977 Act, and CPR 63.14 does not provide a means of service in relation to them. And line 3, dealing with the splitting of designations. In such a case, the claim form must be regarded as including separate claims in respect of each designation, and CPR 63.14 only provides a means for its service insofar as it relates to the UK designation. So, the claim has to relate to the UK designation. And we say the judge was absolutely right to find that the claim for FRAND declarations here related to the challenged patents. Indeed, as you have seen, is a declaration as to whether an offer made under the challenged patent is FRAND or not. And as Lord Justice Burse explained in Vestel, as we saw at paragraph 71, the mere fact that the FRAND licence may go wider than those 3 UK rights does not prevent the claims being wholly or principally concerned with those 3 UK rights. That's the Gateway 11 test, wholly or principally concerned with. That, of course, is a more exacting test than relating to, which is the test under 63.14. If, as we say, the reasoning in Vestel paragraph 71 is correct, which we say it plainly is, then the FRAND declaration claims do indeed relate to the challenged patents. They relate, as we have seen from their drafting, only to registered rights under the 1977 Act. And the judge was clearly right to find that they could be served through 63.14. And Interdigital's only argument to the contrary in its respondent's notice seeking to challenge the judge's conclusion on this is that the judge's approach would involve impermissibly permitting the convoying of claims in relation to foreign patents in the manner disparaged by the court in Activis. But that is wrong precisely for the reasons explained by Lord Justice Burse in Vestel. The fact that the FRAND licence goes beyond the challenged patents does not mean that a claim in relation to the FRAND licensing terms for those patents is not still wholly or principally concerned with UK rights. And on that basis, it most certainly is relating to
So
UK
you say
rights.
it's a contractual defence to infringement of UK rights. And it doesn't matter, they haven't been asserted yet. And it doesn't matter that you say that a licence wouldn't necessarily be granted, because even in that scenario, you would have a defence to an injunction.
That is certainly one way of putting it. That's the Lord Justice Burse tort claim analysis. So it was also something accepted in Alcatel and Amazon. That's one way of putting the point. Yes, I agree. Another way of putting it is simply to say that this is a claim for declarations as to the effect of contractual obligations attaching to 3 pieces of UK property, UK registered rights. Or
Well, that's
if
looking at it perhaps slightly more through the Gateway 11 lens.
possibly, but what we say is that if
You say it's the same.
yes, it's very difficult to see how, if Vestel paragraph 71 is right, and we say it clearly is, the relating to test is not also met. And that's essentially what the judge finds in 103. And if the judge was right on that, then a lot of the debate about the gateways becomes irrelevant. Because if D2 was properly served under 63.14 with both the patent claims and the Fran declarations, then it's difficult to see how D3 and Avanci are anything other than necessary and proper parties to the Fran part of the proceedings. D3 is, of course, the entity which actually gave the Fran commitment, and Avanci is the licensing agent and has indeed made clear that if the claim is proceeding, then it wishes to be involved. If you're not with me on that, then we have to get into whether the Fran declarations pass through a gateway other than Gateway 3. The judge held that he would have had no hesitation in finding that the Fran declarations claim against D3, if arguable, passed through Gateway 11 on the basis of Lord Justice Burse's reasoning in Vestel. That's paragraphs 127 to 128 of the judgment. And we say he was right on that. And the same logic would also apply to D2, which also owes an ETSI obligation as an affiliate. And Mr. Raphael takes a respondent's notice point that Vestel is wrong on that issue. And in response to that, in a sense, I can do no better than rely on the judge's quite comprehensive reasoning for rejecting that argument at paragraphs 44 to 45 of his judgment, which is Core Tab 10, page 123. And we say the judge absolutely rightly recognised that although strictly speaking obiter, these dicta are part of a very careful analysis in Vestel of how the scheme fits together And, perhaps more importantly, they are consistent with the logic of Unwide Planet itself, which obviously is the critical thing here. Unwide Planet decides that the FRAND license under a single UK set may be a global one under many other patents. And that being so, it's perfectly logical to say that you can have a claim which is wholly or principally concerned with UK rights, but where the FRAND license under those rights with which the claim is wholly or principally concerned is a global one. Now, Mr Justice Fancourt in this case is not the only judge in the High Court to have reached the same conclusion about the correctness of Vestel on this issue. As I showed you earlier, Mr Justice Zaccaroli, as he then was, in Alcatel and Amazon, reached the same conclusion. That was, I showed you earlier, Authorities 1, Tab 3, and at paragraphs 116 to 120, Mr Justice Zaccaroli, as he then was, rejected the argument that Vestel was wrong. So you say the judge was absolutely right to hold that the FRAND declarations claim against Interdigital would have got through Gateway 11 in any event, even if it didn't go through 63.14. As regards Avanci, the judge indicated in paragraph 129 that he would have held that Gateway 11 did not avail Tesla against Avanci because there needed to be a claim of right against Avanci itself. Now, the judge rightly observes that that wouldn't matter because Gateway 3 would be available against Avanci anyway. But for all of the reasons I explained earlier, in any event, we submit that that is the wrong reading of Vestel, and it is inconsistent with the general law on declaratory relief. So we say FRAND declarations clearly do pass through Gateway 11 as against all defendants, including D2 insofar as I need to make that submission, i.e. if 63.14 wasn't available. And to the extent that the FRAND declarations claim goes through against any defendant under 63.14 or 11, then Gateway 3 is available against the others. So that's what I wanted to say on 63.14 and the gateways. That then brings me to the sixth topic, which is appropriate forum. The judge's conclusions on appropriate forum are, as he explained in paragraph 125, obiter. And they are obiter because he had already resolved the applications on the basis of no serious issue to be tried. On the forum issue, the judge's obiter holding was that Tesla had not shown that this court would be a more appropriate forum than the Delaware Court of Chancery as a forum for the dispute. Before I get into the detail, I do say that that conclusion illustrates the undesirable asymmetry created by the judge's decision, to which I referred earlier. Following Unwide Planet and Huawei, Conversant and Huawei, and Nokia and Oppo, all of which we refer to in the skeletons, footnote 10 and paragraph 90 of our main skeleton, a person implementing a standard here in the UK will always be liable to be sued on a single UK SEP with a view to establishing and settling global FRAND licensing terms. Despite the fact that these portfolios and pools are generally global, the English courts will, following the reasoning in the Conversant case and the Nokia and Oppo case, almost invariably be the proper forum because FRAND is regarded as being part and parcel of the infringement claim, and so the forum question answers itself. But the very same implementer liable to be sued in that way would be unable, under the judge's approach, to bring declaratory proceedings to establish what the licensing terms applicable to those very same patents are proactively, so as to avoid infringing the patents in the first place. And that asymmetry would, we say, be contrary to the need for a well-functioning dispute resolution system in FRAN cases, which has been emphasised by this court on at least 2 occasions recently in the Interdigital Novo and Panasonic and Xiaomi case. The FRAN claim in this case seeks to establish the FRAN licensing terms relating to the 3 UK patents in suit, and more broadly, the UK steps in the Avanci pool. That's the pleaded claim, the pleaded relief sought. But the judge found that the more appropriate forum in which to bring the claim was the Court of Chancery in Delaware.
Just on the asymmetry point, I mean, I don't think this really matters to either side's case, but one thing that struck me, reading the judgment of the Skeletons, is that there's no reference, so far as I can see, I may be there, I may have overlooked it, to the fact that in this context, a declaration of non-essentiality is the same as a declaration of non-infringement in other contexts, because the basis for the claim for infringement is always essentiality, or almost always. And therefore, if you get your declaration of non-essentiality, that's tantamount to a declaration of non-infringement.
Yes. And my Lord, that is a point which Lord Justice Burse makes, I think in paragraph 12 of Vestel. He says that in that, one of the things in that case that was notable was that the claimant had not invoked the machinery under the Patents Act to seek a declaration of non-infringement or to revoke any of the patents in the pool. Yes, it is paragraph 12 in Vestel. It is also a point made by Mr Justice Saccaroli in the passage of...
Yeah, but I don't think anybody's suggesting you have to bring yourself within the confines of Section 71.
No.
The whole point is that there's what patent lawyers like to call the inherent jurisdiction, but perhaps should properly be called the general jurisdiction.
Yes, my Lord, yes. And so this is a claim tied to UK registered rights. The pleaded relief is tied to UK registered rights. But the judge found we should have gone to Delaware. And such a claim in the USA, even if we're just talking for a moment, and I'm going to come to characterization in a moment, but even if we are just talking about a claim to set global FRAND licensing terms, such a claim in the USA would be unprecedented. It is common ground on the evidence that the US courts have never set global FRAND licensing terms without the consent of both parties, whether relating to a pool or otherwise. And I accept, of course, that there are plenty of authorities to which my learned friends refer, making clear that the identification of an appropriate forum is a matter, in the first instance, for the judge. Now,
but as I understand it, your first point is you say that there has to be an available alternative forum, see Unwire Planet, and you say there isn't.
well, that's certainly right. That's one of a number of points that we make.
Now that leads to this question. What is the test for deciding whether another forum is an available forum?
Well, I think I can start by saying it's certainly not the test which the judge applied. As we will see when we come to it, the judge asked whether the question was one of whether we would receive substantial justice in the USA or not. And that is the wrong limb of the test. That is the fallback limb of the discretion on forum non-convenience for cases where the forum can be shown with cogent evidence to be one in which substantial justice would not be received, and it brings into that brings up all the cases like the Kyrgyz case that I showed you earlier. That's not the relevant question at this stage. Nobody is suggesting that the US courts fall within that category. So that is certainly one of the errors of principle that we identify in the judge's approach. As to whether an alternative forum is available, I'm not sure one needs any gloss on the word available. I suppose the question is, what standard does one have to meet?
Well, yes, that may be the right question. So is it balance of probabilities or what? I mean, one bears in mind what happened in Unwired Planet, where the Supreme Court said there was no available alternative forum because it was a matter for speculation as to whether the Chinese courts would do it or not, and that was not enough.
Yes.
And 2 days after the Supreme Court decision, the Chinese court said they would do it.
Yes, indeed.
So 2 days later, one would have known that
Yes.
there was an alternative forum.
Yes, and my lord, certainly that, of course, that decision would suggest that simply showing that there's a speculative possibility that a foreign jurisdiction would accept.
So what's the test?
I don't think one can say that it's balance of probabilities, because that would be inconsistent with the overall approach to it being an interlocutory question. What I can say is that the courts have certainly taken risk that a forum will not be available into account in the forum analysis, including on availability. There's the Otsuka case I was going to talk to in a moment. The standard.
So what happens if we take the view that there's a 10% chance that the US courts would do it? So one might say that's not speculation, that's judicial estimation, but on a balance of probabilities test that would not be enough. You say you fail?
My lord, no, I wouldn't say we fail at that, because then that is, in my submission...
So 10% isn't good enough? 20%? I mean, what is the test?
My lord, I shall reflect and reconsider the authorities and consider whether there is any assistance I can give you on that. I can't, having studied them, recall this issue as to the relevant standard having actually been addressed. They simply ask the question, is the forum available or not? And I don't want to attempt to make that up on my feet, as it were.
Yeah, but this case raises the question quite critically, because the gravamen of your evidence, as I understand it, your expert evidence, is that it's not jurisdictionally impossible for the US courts to do it, but it is unlikely, without qualifying the degree of unlikely, but let's just say improbable that they will. And therefore, if balance of probabilities were the right test, one might say that that's not enough. I think you do say that.
I think the likelihood or otherwise of the foreign jurisdiction accepting the claim is, in the final analysis, part of the overall assessment.
That's not how the Supreme Court dealt with it in Unwired Planet.
No,
they said you don't get into the final assessment because there's no alternative forum.
Yes.
Because it was speculation.
That is true. That is true. And so I think I'm entitled to make the submission based on Unwired and based on the Otsuka case, which I will show you.
Well,
that if there is,
maybe we should look at those too.
Yes, I should come to that. But you will only get there if I can satisfy you that there is an error coming within the relevant categories in the judge's assessment of forum issue.
Yes.
And when I showed you Interdigital and the Novo earlier, so that we didn't need to go back to it, I showed you paragraph 168, which refers to the various categories of error which qualify: significant error of principle, wrong by reason of identifiable flaw in logic, lack of consistency, failure to take into account a material factor, etc. And we do say that the judge's obiter conclusions on forum contain really a series of errors of that character. First of all, the judge failed to recognise that as regards D2, based on his own analysis under 63.14, the burden of proof lay on D2, not on the claimant. That's the first point. The second point is we say the judge failed properly to characterise the claim, resulting in him effectively ignoring the UK patent claims when they ought, in accordance with Lungo and Vedanta, to have had very great weight. That's the second point. The third point is the one that I've already adverted to, which is that the judge applied the wrong part of the forum conveniens test when asking whether Delaware was an available forum. The fourth is that the judge misunderstood the nature of the issue arising under US law as being a point about discretion as to remedy, when in fact it concerned a fundamental point about the justiciability or otherwise of global FRAND claims under US law. And the fifth point is the judge failed to address Tesla's point that even uncertainty as to the foreign jurisdiction was an important factor. Can I develop those in turn? The first point about burden of proof, this is the point we make at paragraph 24 of our supplemental skeleton. It's common ground between Tesla and Interdigital that unless Interdigital's appeal on CPR 63.14 succeeds, its cross-appeal, or however one characterises it, then the burden as regards forum conveniens ought to have lain on D2, not Tesla. If D2 was properly served within the jurisdiction with the FRAND declarations claims, then this was a service in case. Mr. Raphael accepts that at paragraph 76 of his skeleton, but describes it as a technicality. It is not a technicality. The founding of jurisdiction as of right can be of considerable relevance, especially in commercial cases where there is no natural forum to decide an issue. And this is a point that the House of Lords made in Spiliada, which is in Authorities 2 at tab 41. At page 277 of the bundle, page 476 of the report. And at page 476 of the report, there's a very familiar set of principles that have been sidelined, and those relate to cases, service in cases where one's asking for a stay on grounds of forum convenience. And next to F, Lord Gough raises the question, it's pertinent to ask whether the fact that the plaintiff has, ex hypothesi, founded jurisdiction as of right in accordance with the law of this country, of itself gives the plaintiff an advantage in the sense that the English court will not lightly disturb jurisdiction so established. And then there's reference to the position in the US and Canada. A more neutral position having been adopted in the Société du Gaz case. And at C, on 477, furthermore, there are cases where no particular forum can be described as the natural forum for the trial of the action. Such cases are particularly likely to occur in commercial disputes where there can be pointers to a number of different jurisdictions. I can see no reason why the English court should not refuse to grant a stay in such a case where jurisdiction has been founded as of right. It is significant that in all the leading English cases where a stay has been granted, there has been another clearly more appropriate forum. In my opinion, the burden resting on the defendant is not just to show that England is not the natural or appropriate forum for the trial, but to establish there's another available forum which is clearly or distinctly more appropriate than the English forum. In this way, proper regard is paid to the fact that jurisdiction has been founded in England as of right. And in the VTB case, the Supreme Court again made the point that the distinction between service in and service out is an important distinction. That's Authorities 3, tab 53, at paragraph 12. And the judge's reasoning failed to recognise this point at all. At paragraph 130 of his judgment, he proceeded on the basis that the burden lay on Tesla throughout. Which was inconsistent with his own finding in relation to 63.14. And that is, in my submission, in and of itself, a clear error of approach which would justify the court reperforming the assessment again on a proper basis. That's the first of the 5 points on this.
Yes, but before you go on, was the judge referred to this court's decision in Nokia and Oppo, holding that there's no natural forum in these cases?
I am fairly sure that he was, yes.
It's not anywhere mentioned in the judgment.
No. I say fairly sure because I don't have the transcript with me, but I can check that. But obviously the reason, part of the reason I take, my lord's ahead of me, part of the reason why I take the court to Spiliada and to the point made by the House of Lords that the burden may be particularly important where there is no natural forum is precisely because this court said, of course, in Nokia and Oppo, that these FRAND disputes have no natural forum because they're generally decided on the basis of expert evidence which could just as well be called in an international tribunal or in the English court or in the US court. But my lord, I can check that. I'm fairly sure he was referred. The second error relates to characterisation, and we deal with that at paragraphs 74 to 79 of our main skeleton. And we say the task is to characterise the whole of the dispute, encompassing all of the claims made. That is Lungo and Vedanta, which is in Authorities 3 at tab 51. This was a claim by Zambian citizens for personal injury and other harm suffered because of pollution and environmental harm said to have been inflicted in Zambia by a UK company and its Zambian subsidiary. And the Supreme Court considered the approach to characterisation at paragraph 66 onwards, which is page 1586 of the bundle. Paragraph 66, to start with, makes the point that proper place in which to bring the claim is simply a modern day anglicisation of the original Latin. And just above B on 1071, Lord Briggs says the best known fleshed out description of the concept is to be found in Lord Gough's famous speech Spiliada, summarised much more recently by Lord Collins in the Altimo case as follows. The task of the court is to identify the forum in which the case can suitably be tried for the interests of all the parties and for the ends of justice. And we can see at 68 that Lord Briggs says there can be no doubt that when Lord Gough originally formulated the concept quoted above, he would have regarded the phrase "in which the case can be suitably tried for the interests of all the parties" as referring to the case as a whole, and therefore as including the anchor defendant among the parties. Although the persuasive burden was reversed, as between permission to serve out against a foreign defendant and the stay of proceedings against the anchor defendant, the court was addressing a single piece of multi-defendant litigation and seeking to decide where it should, as a whole, be tried. The concept behind the phrase is the forum and the proper place is that the court is looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried. And then there's reference to Owusu and Jackson and the problems that that is well known to have thrown up, but which didn't arise here because we're concerned with the Isle of Man. An unspoken assumption behind that formulation of the concept of forum conveniens or proper place may have been that a jurisdiction in which the claim simply could not be tried against some of the multiple defendants could not qualify as the proper place, because the consequence of trial there against some of the defendants would risk multiplicity of proceedings about the same issues and inconsistent judgments. But the cases in which this risk has been expressly addressed tend to show that it is only one factor, albeit a very important factor indeed, in the evaluative task of identifying the proper place. So a very important factor indeed. And the court is looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried. That's paragraph 68. And in footnote 10 of our skeleton, we give further references to conversant and to Nokia and Oppo on that issue. I am told that we did indeed draw attention to Nokia and Oppo and the no natural forum point in paragraph 101 of our first instance skeleton. Now, the judge's characterisation of the claim, however, gave no weight to the patent claims at all. If we go in the judgment to paragraph 131, which is in Core Bundle tab 10 at page 141, I shan't read the whole paragraph, but where one gets to in the end is the judge says, well, I know there are these patent claims, but I'm going to characterise it as a licensing claim. And analyse it accordingly.
So you say the flaw is in the last sentence, where an implementer starts proceedings such as these and undertakes to take a licence on FRAM terms, they cannot expect the proceedings to be characterised as a dispute about UK patents, unless the claim was issued in response to a threat of an injunction. You say, well, the whole point of this exercise is to ensure that you can't be threatened with an injunction.
That's absolutely right. And indeed that sentence is contrary to all of the law I showed the court earlier, to the effect that an implementer ought, as a matter of principle, to be able to bring declaratory proceedings precisely for that purpose of establishing the FRAN licensing terms which it must sign up to if it wants to launch in the UK. None of these, well, the case, to use Lord Gough's expression that we were just looking at, unquestionably has to include the UK patent claims for revocation and declarations of in essentiality in relation to 3 UK patents. And those are claims which everybody accepts can only be tried in the UK. That is a factor which, according to Lungo, as I just showed you, ought to have been, as they put it, a very important factor indeed in the characterisation. And yet paragraph 131 generalises the patent claims out of existence. And then they simply don't crop up again, really, in the analysis, or at the very least they are not given very substantial weight. So we say that was another error of approach on the issue of forum convenience. Now, Mr. Raphael cites in his skeleton some cases, paragraph 63, in support of a submission that, as he puts it, the tail should not wag the dog. But you will see when you're taken to them that none of those cases was concerned with claims which could only proceed in England. And a foundational problem with the approach of the judge and on the other side of this court to the forum issue is they simply leave the patent claims out of account altogether. That's the second of my 5 points on this. The third error was applying the wrong part of the forum test when asking whether the USA was available as a forum. That's the point we make at paragraphs 82 to 83 of our skeleton. What you will see in paragraph 136 of the judgment is that the judge was asking whether the risk of the Delaware Court of Chancery not setting a global FRAND rate was, in his words, sufficient to mean that Tesla cannot obtain justice there. And that is, as I say, that's the wrong part of the test. The question is not that fallback limb about injustice in foreign courts. The fourth issue with the judge's analysis was his misunderstanding of the nature of the issue with US jurisdiction. That is addressed at paragraphs 84 to 87 of our main skeleton. Now, this is a case where there was no cross-examination of the expert witnesses. It is an issue arising in a fellow common law system. We give you the authorities in paragraph 81 of our skeleton on how to approach expert evidence. This is a case where this court is in as good a position as the judge was. And Professor Contreras was very clear in his evidence that the US courts are unlikely to entertain a claim for the determination of global FRAND without the consent of the parties. That in fact to date no US court has done so, and that even if the parties did consent, the court might still not entertain the claim. And I should show you his evidence on that. It's in the supplemental bundle at tab 14.
Can you just tell me, Professor Contreras is an extremely well-known expert on this subject matter. What were the qualifications of the other two experts, briefly? Mr. Kamprath, Mr. Kessler?
Yes.
I should have looked, but I haven't.
Well, Mr. Kamprath, I would need to check. His reports haven't been put in the bundle. He didn't actually disagree with what Professor Contreras said.
Right.
Mr. Kessler did. Mr. Kessler is a very well-known US trial lawyer.
Right.
And acts for Avanti.
Okay, thank you.
In his cases in the USA. Professor Contreras' evidence is in the supplemental bundle at tab 14. And at page 101, you can see the start of the report. His evidence is summarised in paragraph 8 at page 103 of the hard copy bundle. And we can pick it up at C about halfway through, accordingly, Tesla's most likely claim in the US courts would be a breach of contract action in which Tesla would assert that Interdigital has breached its obligation to offer Tesla a license under Interdigital's 5G SEPs on FRAND's terms. As part of a breach of contract action, a US court will be able to assess whether Tesla is a beneficiary of the FRAND commitment. However, absent the agreement of both parties, it is unlikely that a US court would determine the terms of a worldwide FRAND license, and some US courts may refuse to do so even with the agreement of both parties. I understand from Pal Gilbert that neither Avanci nor Interdigital has consented to be bound by a determination by the US courts of the FRAND terms. Now, to understand the basis for that, one then needs to look at the law that he cited in that regard, and we can look, for instance, at paragraph 37 on page 110. The judge refers to it being well established that a US court will not adjudicate the validity of a non-US patent. And in the second half of the paragraph, the judge refers to Voda and Cordis, in which the Federal Circuit explained that only a few reasons might justify a US court taking jurisdiction over a foreign patent matter, none of which seemed to be relevant. And the reason I draw attention to that is that that is then picked up further when Professor Contreras came to explain in paragraph 71 the position in relation to setting FRAND rates for non-US patents. In line 5, Professor Contreras said, just as it is unlikely that a US court would adjudicate the validity of a non-US patent, it is also unlikely that any US court would adjudicate a FRAND rate for UK patents. This point was expressly addressed by the Federal District Court in Optis against Huawei, which dismissed the implementer's contractual claims relating to the SEP holder's alleged breach of its FRAND obligations with respect to foreign patents. And there's a citation from the reasoning. And then there's reference to a further case called Optis and Apple, which had stated that, like claims for foreign patent infringement, claims asking the court to pass upon foreign obligations under foreign laws related to foreign patents are best left to the courts of those foreign countries, etc. Now, I'll show you in a moment the reasoning in Optis and Huawei and Optis and Apple briefly. But let me also show you Professor Contreras' second report, which is in Supplemental Bundle tab 17. And we can see at paragraph 12, page 147, that Professor Contreras remained of the view that it was unlikely that
There's
a
a
US...
typo in line 3. Should say with, as we've just seen.
Yes, indeed. That's quite right. And in 13, I've been asked to comment on what Avanci and Interdigital would need to consent to in order for a US court to make the determination. Specifically, a US court would be likely to require that Avanci and Interdigital, as well as Tesla, consent to the determination of whether the terms of the global Avanci 5G pool license, i.e. including both US and non-US patents, are FRAND, and if not, to waive any objection to the determination of FRAND terms for both US and non-US patents under a global license to the Avanci 5G pool. And he goes on further to explain his opinions. Now, as I showed you, the professor's evidence made clear that the reluctance of US courts to set global FRAND rates to date has arisen from Voda and Cordis concerns about comity and justiciability of foreign patent claims. And the two cases that he referred to were Optis and Huawei, which are in the authorities bundle at tab 57 and 58 respectively. We can start at 58. And the Federal District Court at page 1805 dealt with Huawei's motion to dismiss count 9 of the complaint. And we can see in the 7th line under the heading, in addition to raising issues about United States patents and United States FRAND law, Huawei points out that the declaratory judgment claim implicates foreign patents and foreign FRAND. And moving on in the next column, next to the first hole punch, if the motion did not involve a declaratory judgment claim, instead was whether supplemental jurisdiction could be exercised to resolve a claim by Huawei that Panoptis breached its FRAND obligations, then the foreign part of Huawei's claim would be dismissed under section 1367. Huawei's claim would require the court to decide whether Panoptis breached a foreign FRAND obligation with respect to a foreign patent. And I shan't go on, but one sees the concerns outlined in terms of justiciability concerns arising from Voda and Cordis. And in the previous tab at 57 is Optis and Apple, where the reasoning on pages 1794, under the heading "The Court declines jurisdiction to declare rights as to foreign patents or foreign obligations," is to similar effect. And this is not a hypothetical point, it is an objection that Avanci, in a brief authored by Mr. Kessler, has actually taken in a previous case. You can see it in the supplemental bundle at tab 8. Avanci opposed Continental's declaratory judgment claim, asking the court to declare a FRAND rate under the Avanci court. And at page 81, we see that Mr. Kessler, on behalf of Avanci, in line 17 to 18, said Continental cannot overcome the fact that this court does not have jurisdiction to dictate terms and conditions of a license where many of the patents at issue are granted by foreign jurisdictions. And he then cited the cases that we've just seen referred to in those decisions. For what it is worth, that was the finding that Professor Contreras, or the opinion of Professor Contreras, is the same finding that was reached by the High Court in the Interdigital Lenovo case by Mr. Justice Mellor, as Dr. Hopewell pointed out at paragraph 60 of her third statement. There is a suggestion that that judgment is inadmissible, but as was explained in Mex and Ford that I showed you earlier, Hollington and Hewthorne applies only to fact-finding at trial. That's paragraphs 29 of Mex and Ford. Now, Mr. Kessler essentially drew attention to the fact that in a Continental action against Nokia, the action had survived a motion to dismiss before it was eventually withdrawn. And I can't take you through it all, but Professor Contreras explained in his second report, at paragraph 17, quite what limited significance one can attach to the failure of a motion to dismiss. Now, neither Avanci nor Interdigital has consented to the US courts performing the exercise which we see, and it is therefore unlikely, we say, that the US court would entertain the exercise which lies at the heart of the FRAND declaratory claim, i.e. setting the global FRAND rate. And no one has identified any example of the US courts ever having done that without the consent of the parties. Now, the judge seems wrongly to have thought that this was just an issue about the grant of a particular form of relief, that our argument was simply a parochial argument about a form of relief that you might get in England. And Interdigital picked this up in their respondent's notice. But we say that's clearly not right. The point goes to the heart of the central reason why, on Avanci and Interdigital's preferred characterisation of the proceedings, we are here at all. They say these proceedings are all about setting a FRAND rate. But this evidence shows that it is unlikely that the US courts will do so unless they offer their consent, which they have not offered. The fifth error was then failing to recognise that even uncertainty is capable of being an important factor. That's paragraph 88 of our main skeleton by reference to the Otsuka case, which I think have time to turn up. Those 5 errors, whether individually or cumulatively, vitiate the judge's obiter analysis of the forum issue. That justifies and requires this court to exercise the discretion afresh. In exercising that discretion, in my submission, it's important to start with the correct burden of proof. Unless Mr. Raphael succeeds on 6314, as regards D2, he needs to persuade you that the USA is clearly and distinctly more appropriate. And if he can't, the claim will proceed against D2 anyway, and Avanci has said it wishes to take part. As regards D3 and Avanci, by contrast, the burden would lie on me, but we say when you exercise the discretion afresh, that D2 cannot discharge its burden, and that we can, that England is clearly or distinctly the appropriate forum. England is the best and indeed the only forum available to deal with the patent claims themselves. That is a factor deserving of very great weight for the reasons set out in Lungo and Vedanta. The claim about a licence is about what would be FRAND under the UK patents, whether it be the challenge patents, the Interdigital UK portfolio, or the UK patents in the Avanci pool. We're asking for a determination of what terms Tesla must sign up to be able to launch 5G vehicles in the UK. And insofar as the claim concerns global rate setting, that is an exercise where the Court of Appeal has recognised, applying the connecting factors, that there is no natural forum and where the domicile of the parties is of little, if any, weight. And that's the Nokia and Oppo case that we've already discussed, which is referenced in our skeleton argument. It's in Authorities 3, tab 30. By contrast, any like claim would be unprecedented in the USA, and there is very considerable doubt indeed as to whether a US court would resolve it. And as we point out in our evidence, the Patents Court is experienced and specialist in this area. The documents all appear likely to be in English, and there are no proceedings underway elsewhere. The governing law of the SPLA, on which some reliance was placed, is deserving of no weight at all. There is, so far as I am aware, no dispute as to the interpretation of the SPLA. But in any event, there is a confidential factor which I should show you, which is in the core bundle at tab 34. The court may have seen in the summaries of the effect of the MLMN that there is a category of pre-approved modifications which Avanci is able to make to license agreements that it concludes. And if we go to page 422, I cannot read this out, but next to the top hole punch, we have section 10.1. LA in that is Avanci. So we do say that governing law of the license agreement really is not of any assistance in determining the appropriate forum in this case.
Well, I appreciate that's confidential, but how are we going to deal with that in a judgment? I mean, I suppose we could put it in a confidentiality annex, but it's going to make the reasoning a bit difficult to follow.
Yes, I do, I do see that. It may be that ultimately it's decided that that is insufficiently confidential to warrant its current treatment, but I didn't want to breach the agreement on my
Plainly, you were right not to preempt the question. Right. All right, we'll see where we get to.
And then finally, my lords, my lady, the seventh topic of 7, full and frank disclosure, I can deal with, I hope, briefly. We deal with that at 25 to 26 of our supplemental skeleton. We in no way underestimate or minimise the judge's findings on that issue. There is, however, a simple answer, which is that the judge, with full knowledge of the non-disclosures that he had determined, and in the best position to weigh the appropriate response, indicated that he would have exercised the discretion which he indisputably enjoyed not to set aside service on that ground. And he'd been fully and properly directed on the law before giving that indication. We've given you the references to the skeletons below in our supplemental skeleton. My learned friend identifies no error of principle or other category of appealable error in our submission. If the Fran Declaration's claim is otherwise properly advanced, then we do say it would be disproportionate, especially given that the patent claims are proceeding anyway, to require it to be set aside and reserved. And finally, I should say a word about costs. There is a Respondent's Notice Ground 15, which concerns the costs order made by the judge. We have agreed between ourselves that that issue will only arise in the context of this court's consideration of costs in due course, and so we won't be advancing submissions on it. My lords, my lady, I'm 2 minutes over, my apologies, but those are my submissions.
Thank you. Mr. Ruff.
Lord, I'm obliged. My lord, my lord, my lady, Interdigital challenges jurisdiction because this claim is about a licence from Avanci to the Avanci platform, and it's wrong to sue Interdigital alone among licensors. Tesla seeks a licence from Avanci, not Interdigital, which Interdigital cannot grant nor procure the grant of. And the essence of its claim seeks to engage the supposed obligations of 70 licensors collectively, not Interdigital's own obligations, which cannot justify the relief it seeks. Suing Interdigital on its own is incoherent and will do Tesla no good at all, and the idea that Interdigital can sensibly represent all the other licensors is fanciful. I'll come back to that. Interdigital therefore says that there's no serious issue to be tried against it, and in any event the claim doesn't pass through relevant gateways, and the USA is the appropriate forum. So jurisdiction should be refused, alternatively the claim should be struck out. The judge so held, and his result was correct. I'll set out first the background, and then turn to analysis. But one thing I'd ask you to bear in mind going through is the artificial nature of the framing of Tesla's claim, and in particular, its declarations. And that's because there is no natural gateways for what they want to do. This is really a contractual claim, at its highest, about licensing of patents worldwide. That is really what it's about, despite many attempts to secure...
Why is that any different from the usual set dispute? Unwired Planet, for example. That, in truth, was a contractual claim about worldwide licensing as well, and the Supreme Court said we've got jurisdiction.
It's a claim for infringement, my lord.
So what? This is just the obverse.
Well, it's not, because the cause of action is totally different, my lord. There is an asymmetry, a very distinct difference. In an infringement claim, you claim for patent infringement challenged by validity, which can only happen here, and an incident of that claim is the determination of a license in certain circumstances. But here, the cause of action is to say, you owe me a contractual obligation under French law. And that presents a totally different situation. And in particular,
I'm really sorry, but I'm struggling to hear you. I've got some noise at the side, and
yes.
I'm losing you, I'm afraid.
Fine, thank you very much. Well, it is entirely, when you understand what the cause of action is, so far as one exists, it is a claim to enforce the ETSI undertaking. It's a contractual claim, and for that reason the patent claims are entirely irrelevant. As held in Lenovo and Ericsson, they are not conditions of that contract. Now, it is true there may be a temptation to see a symmetry that does not exist. But once one understands the reality of this claim is simply contractual, you can see that there are no natural gateways for it. And Tesla are forced to try to reshape their claim in an artificial manner to deal with that problem. They reshape it artificially to try to fit through Gateway 11. I'll come back later to why that doesn't work. But what I want to stress is the interplay between the problems Tesla faces. At some point, it seeks to identify a useful purpose, which is not its useful purpose, as an attempt to deal with the problems it faces on the way it formulates its claim. At others, it seeks to reformulate the claim to slip through gateways. But when one keeps one's eye on the centre of its claim, which is a claim for a worldwide license under an alleged contractual obligation, you will see it neither has a useful purpose or coherent claim against Interdigital, which is all I am concerned with, nor does it fit through a gateway. Well, that's a by way of introduction. And I'll now turn to some factual background points before analysis. But there are two documents I'd like to hand up, if I may. Two. That's three. Just to explain these, first is you'll see in the bundles there's an A3, there's a printout of Avance's website, but it's very, very small. So we've printed that out onto A3 so you can see it more clearly, and that's the bigger document.
Thank you.
And the other arises out of confidentiality concerns. There are some things I'm going to find difficult talking about openly, so I've just written down the submission on the A4 piece of paper so that I can make it without delaying the court.
Thank you.
Lord, so the first point is the platform. And for that purpose, I'd like you to look at the A3 document I found out by and ask you to do so. And this is from Avance's website. On the first page, you see one license, 70 licensors. This is changing all the time, of course.
Yeah, so the more have joined since the judge's judgment.
More have joined since the judge's judgment, more have joined since the Ladden-Marshall evidence. We don't rely on that as new evidence, but simply that's the nature of this thing. It's constantly going to be expanding. Then you also see all the licensors on the second page. Now, in May, when it was before the judge, there were over 170,000 patents in the platform, which was nearly 90% of the worldwide stack. That was on the basis of 65 licensors. It will now be more. But that puts in stark light the total unreality that the patent claims under 3 patents have any role at all. Then, looking at the names of the licensors, you see those names. Now, other members of the platform, you'll see many of these names are very familiar. I won't read them out, but the court will be well aware of them, not least from the multiple cases that have been before the courts in recent years relating to FRAND. Many of those licensors are much more significant than Interdigital. There's a ranking at Annex 2 to the particulars of claim, Core tab 19, page 225. All of the top 10 in that document, which I don't think we need to turn up, are members. Interdigital is 10th, others are much more significant. As to Interdigital's share, it doesn't actually know that, because that's Avance's information. But in May we gave a percentage estimate, which you'll find in supplemental bundle tab 23, page 237 in my physical version. It Is using the physical references going to work?
No, not if we're in the supplemental. Is that where you want me to go?
It is, yes.
You're a few pages out, but I can usually catch up. So, what was the
So the document is
237?
yes, 237.
What are we looking for?
We're looking for paragraph 7 of Brodie 4. I'm afraid it appears I have a incorrect reference. 256.
That's the cover sheet.
It is Brodie 4, 256. At paragraph 7 of that, you see page 257, 258. You see the confidential figure for Interdigital's patents of its own, and you see the percentage figure for Interdigital in paragraph 8.
Okay, I'm lost. Brodie 4.
Brodie 4, page 258 of the
Which
physical
tab
bundle.
is that in the?
It's in tab 23, my lady.
Paragraph 8.
Yes. Is your ladyship's page 2 ahead of mine? Or?
It's the electronic. If I'm searching, it's page 260 in the bundle, so it's 3 or 4 pages out.
We'll try to add 2 pages.
Well, don't worry, I'm mostly managing.
I'm
If you just give me the page as you see it, then I can work out where I'm meant to be.
I'm very grateful. The platform also has a voting base share, which is derived by a weighted metric, and you see that at the next page, which is ELEO. And as of 14th of May, there's a base share figure which is set out there. Now, turning back then to the, but of course it will now be lower. Turning back to the names, you will see from them that they are very familiar from the law reports, and many of those have been litigating each other busily in FRAN disputes about portfolio valuation in these courts. So just using English law reports, Huawei have sued ZTE, Unwide Planet have sued Huawei, Phillips have sued TCL, Oppo and Asus, Mitsubishi and Sisvel sued Oppo, IP Bridge sued Huawei, IPcom sued Vodafone. A number of those are ongoing, and worldwide it's obviously more. And I'll come back to that later, but the idea that there are no conflicts of interest between these licensors is entirely fanciful. The second aspect on the platform is the MLMA itself. Now, that's confidential, and to deal with that problem, I've handed up the 2 A4 page document that you should have before you. The first page of that is essentially just our skeleton, expanded slightly to deal with extra points I wish to make. The confidential material is in blue, stuff that was not in my skeleton is in italics. Taking the high points here, so the MLA is agreed between Avanci and each member individually. Avanci is authorised to enter into a standard term patent license agreement with licensees, only with certain pre-authorised modifications in Avanci's discretion, and then you'll see some blue wording there, and we give you the references. Each license is a contract between Avanci and the licensee, and then you see there's some blue text there. It's not shared with members. Negotiations are between Avanci and licensees. Importantly, each license relates to all the platform patents of all members. Avanci has no authority to license a subset. That's relevant to the idea that this could be a claim as to Interdigital's patents. It cannot. Members can leave the platform, and then you see some blue text, and Teza accepts that that is not prevented. Then there's a point about, in italic blue, at the end of A, which relates to some of the submissions that my learned friend made about Avanci acting as agents for the members. Then B, I think you'll be aware of. Then moving on to C, this is very important. Outside the pre-agreed modifications, the advancee cannot vary the term of the SPA without members' consent. If, in its reasonable judgment, it considers revised terms should be put to them, it proposes them, and the approval of members with, and then you see a blue figure, is necessary, but also you see each member with a threshold share. You see what that share is I would say sufficient, actually it's necessary to effect revision. Now, Interdigital does not have a threshold share, and it's not one of the largest members, and you see that others are larger. And then you see there's some very important blue text in the last sentence of C. Now, the platform operates on a hub-spoke basis. Advancee alone deals with the licensee and does not need to refer back to C. The licensors interact with Advancee separately. Indeed, information provided by one licensor to Advancee is confidential against the others. Anything to do with comparables, anything to do with valuation is therefore going to be held by Advancee alone. We will not see any of that information from other licensors. And that is not an accident. It is because the licensors are competitors, and there would be major competition law problems if there was sharing information. So the central points that arise from this are: only Advancee can offer a platform license. None of the licensors is given any authority by the MLMA to license each other's patents. Interdigital cannot procure nor prevent the offer of revised terms by Advancee, doesn't have a threshold share, and it cannot satisfy the supermajority. And third, there is no legal right, as a result, to a license against Interdigital. There's no legal right against Interdigital to a license from Advancee. We simply cannot do that. It is not a contract we can perform, so there cannot be a legal right against us to it. Well, that for the MLMA, and the next topic I was going to turn to is FRAND. Now, a key feature here is that Tesla's claim, so far as it relates to licensors, is inherently about the alleged FRAND obligations of all the 70 members collectively. It's not meaningfully a claim against Interdigital alone. There isn't a separate part of the Advancee license that is to do with Interdigital's patents. Now, an important point of context here is it's established law following Unwired Planet in the Court of Appeal, where more than one option would be FRAND within the range of FRAND. The giver of an Etienne can choose to offer the option it prefers to discharge its obligation. The reference to that is Unwired Planet against Huawei at JA 349, paragraphs 121 to 137, but it's a well-known proposition. Now, in that context, Interdigital does not accept that platform licensing has to be FRAND, at least so far as it is concerned. It will, of course, comply with its Etienne undertaking, but its position is it discharges that by being ready to offer a bilateral license to any willing licensee. And it regards the platform license as a commercial alternative which does not have to be FRAND. Now, Tesla disagrees and spends a lot of time arguing about that, but as you'll be aware, we do not take that point at the serious issue to be tried threshold for the purposes of jurisdiction. That is because we do not need to. We have a more direct point for the purposes of this hearing, which is quite sufficient. Because even if you assume that it's arguable that the platform license has to be FRAND, that can only be because the ETSI undertakings of the members collectively require it to be FRAND. None of the licensors have the authority to license the patents of each other. There is no way a license demanded of Interdigital could be a license to the patents of Huawei, Oppo, and so on. And as you've been shown the ETSI undertaking, that ETSI undertaking is only as to the patents of the declarant and its affiliates. It does not apply in any way to other members of the pool.
Nor to Avanci.
Nor to Avanci unless my learned friend argument has weight towards Avanci, but I don't engage with that. Now, with that framework in mind, one should look at Tesla's claim, which you find in the core bundle, tab 15, page 165 of the bundle. Now, I don't really know whether Tesla has an amended particulars or not. I'm probably going to look at both of them for present purposes. Now, the first point to bear in mind is paragraph 1, if I may. So this is a claim for declarations. Two, that the claimants are beneficiaries of FRAND commitments given by the third defendant and other Avanci 5G pool members. It is always collective. It is the whole set. Three, that the claimants have a legally enforceable right to a FRAND license covering the entirety of the Avanci 5G pool. That is the only thing they seek. They do not seek a license from Interdigital. Paragraph 2, in particular, declarations 2 to 4 are being sought because the claimants wish to enter an Avanci 5G pool license. Paragraph 5, the claimants therefore seek relevant relief from this court, including seeking towards their contractual obligation to an Avanci 5G pool license on FRAND terms. Then as we move through, I'm going to have to take this relatively shortly. We'll move to paragraph 31, if I may. And at paragraph 31, you see the FRAND claim, and it relates only to the terms of a Avanci license. There's a disagreement as to rate for that. What you therefore do not have in any sense is a claim as to FRAND terms for Interdigital's patents, which would be an entirely separate enterprise. So far as concerns the challenge patents, there is then the patent claims are identified. It's important that those are entirely disconnected from the rest of the pleading. The allegations that are made as to validity and inessentiality in them are an irrelevance to the success of the patents, of the FRAND claims. And the inessentiality point is only about technical inessentiality. There's nothing else. Then if we move on to paragraph 40, it is pleaded, paragraph 40, that Tesla is a beneficiary of Interdigital's FRAND commitment and is accordingly entitled to a license on FRAND terms covering Interdigital's portfolio. But what is never asked for on the back of that is any claim as to terms from Interdigital. They've pleaded the Interdigital commitment, but they never make a claim that is distinct from the pool. And then if we move on to 41, you see, of course, this is the next step. They're doing it in stages. They plead Interdigital's commitment, and then they plead that they are a beneficiary of the FRAND commitments of all of the Avanci 5G pool members. You will see references to the challenged patents from time to time. But that is solely there as a jurisdictional hook, and it does not change the cause of action in any way. The claim is a contractual claim to enforce the ETSI commitments of all the pool members to get an Avanci license as to the whole pool, nothing else. That will cover the challenged patents, which is the language used, but it will cover every other patent in the pool to just the same extent. And the court we submit looks to realities. Then if we turn on to 42, you see that notwithstanding each advance equivalent is entitled to enter into a bilateral. Now, this Tesla does not want that. It only wants an advance license. The inevitable consequence is it is not a willing licensee to any bilateral license from Interdigital. And you then see the undertaking at paragraph 44, where it is said this: Tesla hereby undertakes the court that it will enter into a license agreement straight after the termination of first instance, covering the entirety of the Avanci 5G pool on whatever terms the court determines at first instance. That is only a license from Avanci. You see that again at 58 and in Hopewell 1, paragraph 68, which is probably worth turning up just in case it was suggested.
Leave that to tomorrow because we're running out of time.
Oh, well, I'm right.
Very good. We'll resume at 10:15 tomorrow.